first lecture in the Conversations About Racism in the 21st Century series. I'm Professor and Vice Dean Joanna Shepard. I'm one of the organizers of this event, along with my colleague, Professor Dorothy Brown. I'm thrilled that we're going to have over 100 faculty, students, staff, and alumni joining us today. Before I introduce our distinguished speaker, I'd like to quickly explain the purpose of this series. This summer, horrific tragedies have reawakened many in our world to the ongoing history and crisis of racial injustice. The murders of George Floyd, Breonna Taylor, Ahmaud Arbery, and other known and unknown African-American victims have been a harsh reminder that anti-Black violence and systemic racism have not been adequately addressed more than 60 years after the civil rights movement began. Unfortunately, racist laws have reinforced these racial inequities in so many areas of our society, including education, banking, healthcare, housing, the criminal justice system, and the electoral system. Emory Law believes that we have a critical role to play in dismantling systemic racism by educating ourselves, our students who will be the future leaders of our nation, and the broader community about the role of the law in perpetuating racial injustice. This series is just one way in which we're trying to do that. We're very fortunate to kick off this series with my colleague, Professor Fred Smith, Jr. Professor Smith is an associate professor at Emory University School of Law, where he was last year named the Outstanding Professor of the Year, the Law School's Outstanding Professor of the Year. He obtained his BA from Harvard and JD from Stanford, and has held numerous impressive positions in clerkships, including clerking for Justice Sotomayor of the U.S. Supreme Court. He is a prolific scholar of the federal judiciary, constitutional law, and local government, and has published broadly in the Harvard, Stanford, Columbia, NYU, and Vanderbilt Law Reviews, among several others. Professor Smith's commitment to equity and social justice extends beyond his professional work. He also serves on the board of Invest Atlanta, the Economic and Community Development Authority of Atlanta. He serves on the Atlanta Mayoral LGBTQ Advisory Board, the National Board of Lambda Legal, and the National Board of Civil Rights Corp. He was also a founding member of Beltline Rail Now, which advocates for transit on critical corridors around the city of Atlanta. Today, Professor Smith will lecture on the role that qualified immunity, as it applies to police officers, plays in reinforcing structural racism. He will speak for about 20 to 25 minutes, and then I will facilitate a short question and answer period to follow. So please use the Q&A function on Zoom to submit your questions throughout today's lecture. Okay, Fred, the floor is yours.
Not how we do it. It is an absolute honor to be the inaugural speaker for this series. And I'm proud of Emory for engaging in these conversations. As I speak to you, I am reminded that although I'm in the city of Atlanta, I'm also on territory that was once Muskogee or Creek territory. And the project that we call law is in some ways a byproduct of a history that involves colonization and theft. I'm also reminded that my great-great-grandparents on land not very far from here were slaves. I have photos of them that I look at with some regularity to remind myself of from whence we've came. It may be odd to invoke or to mention that while talking about qualified immunity, a doctrine that really didn't exist in the 1800s or 1700s or 1600s. It's a doctrine that is a byproduct of actually the 1980s. But one of the things that is central that we do, I believe, in the legal profession is that we must work to produce a generation of lawyers that don't reproduce the injustices of the past by engaging in the application of neutral principles that don't have neutral roots. Because if we do so, we risk that reproduction. And we have to think in a real way about how to make race and how to make issues of stratification and how to make the country's original sins, not things that are at the margins, not things that are simply ands, but things that really kind of structure how we think about our past in order to help us understand our present and to help us better understand the future. And it's my view that lawyers in particular have a special role with respect to these kinds of questions in this particular moment. It's law that helped construct the notions of race that we take for granted today. Recently, I was reading a case from 1806 out of Virginia, Hudgens, where someone was filing a petition to say that they should not be understood to be a slave. That is, in their view, they were not supposed to be deemed slaves. They were being treated that way, and they went to a court to petition for freedom. And these sorts of petitions were not particularly uncommon. And one of the things that the court wrestled with, though, was, well, what does it mean for someone to be presumed to be a slave? Who should be presumed and who shouldn't be presumed? And that particular Virginia court, in a highly influential opinion, explained that one should look to things like skin complexion to see if this person was a person of African descent. One should look to various facial features. The court noted that perhaps the nose is one place where you might look. The court pointed to hair as a feature that one might look to in order to determine whether or not someone should be presumed to be a slave. And although law doesn't so much talk in those terms anymore, they produced categories that we live with today. And it's important to remember that law did that in order to help us make sure that law doesn't reproduce the worst aspects of our history. Law, of course, gave us modern policing. When we see officers shoot someone in the back, when we see officers kneel on someone's neck, we don't simply see one person kneeling on the neck of another or one person shooting another, which is itself a horrific tragedy. But we see the full power of the state itself, right? Using its power in ways that broadly undermine justice and in ways that, in the name of safety, actually make communities feel less and less safe. In the name of community, actually end up making people feel like they are subjects rather than citizens, or perhaps even making people feel as if they are totally estranged from this project that we call the Republic. Law gives us the notion of crime. Law tells us what we will choose to label crime. Law tells us where we will engage in policing, what types of discretion we're going to authorize. Law gives us Fourth Amendment doctrine, which tells us when officers can engage in instances of attempting to seize someone in the first place, when officers can stop someone, when officers can frisk someone, when officers can question someone. Fourth Amendment doctrine gives us this. And the more and more interactions that we have because of hypercriminalization and because of a Fourth Amendment doctrine that makes these encounters quite easy, and because we live in a world in a country where there are more guns than there are people. You put all of this together, and we are demanding so much of our law enforcement. We're demanding so much of our police. And there are inevitable tragic consequences. One of the places as of late that people have looked to, so far I've really been talking about how we got here in prevention, but people have also wanted, in these moments, they want accountability. And there's a sense that there is an insufficient amount of accountability. And accountability can mean lots of things. Accountability could, for example, mean compensation, that someone has been wronged and they want to be made whole through money damages. Accountability could mean some sort of declaration that a practice is unlawful. Simply having someone say, having a judicial body say, that violated the law. Accountability could mean stopping the practice, having a court say, you can no longer engage in the various acts to follow. But the reality is that there's this sense that in so many instances, there's none of that, let alone punishment, when we see people violating other people's rights, when we see agents of the state violating the rights of people who we understand as citizens. And so one of the words that has been uttered a lot throughout all of this, or terms, is qualified immunity. I'm not 100% sure why. That is, it's not 100% apparent to me how qualified immunity got to sort of toward the top of the accountability agenda. But it is, although I don't understand how it got there, it is important, and it's something that I've given a great deal of thought to. But in framing it, I actually want to tell a couple of stories, and both of them are from judicial cases. The first is a Supreme Court case. In the late 1990s, the Supreme Court confronted a case where a woman named Jill Brown was driving down the street in the state of Oklahoma. She was pulled over by someone who almost certainly should not have been a police officer. He pulled her over and without provocation, took her out of the car, slammed her to the ground with enough force that she broke both of her kneecaps. It turned out that this particular officer had a long history of infractions, including a criminal record that involved a number of violent misdemeanors. He had been hired by his uncle. He wasn't given a gun, but he was allowed to be on duty and to pull people over and so forth. And one of the people who Ms. Brown wanted to sue was the sheriff and the county for actually hiring this person in the first place. But the Supreme Court stated, reinforcing a principle that goes back to the 1970s, that when it comes to constitutional violations, one cannot sue the city itself for the acts of its agents, right? Although generally respondeat superior liability, that is lawsuits against an employer for the acts of their agents taken within the scope of their employment, although that's typically the way that employers are held accountable, that doesn't apply in the context of lawsuits against cities. Nor is it sufficient to show that someone who's high up, like a sheriff, engaged in negligence when it came to the hiring practices or any other practice. That is not enough to hold a city liable. Instead, one must show that the city either had an unconstitutional policy or engaged in deliberate indifference to known or highly probable constitutional violations, which itself is a very high standard. And I point that out because when we're talking about qualified immunity, part of why I believe there's such frustration with not being able to sue the officer is because you also can't, in many instances, at least in federal court, for federal constitutional violations, sue the city. The second story is one that I'll tell right here from Georgia. It's a case where a man named Jesse Buckley, who was homeless, he was pulled over, and an officer noticed that when he pulled him over that Jesse Buckley, he just started crying. The officer asked him to get out of the car, and Jesse Buckley said, I can't do anything. I just really want you to take me to jail. I can't believe everything that's happening in my life. And he continued to sob, but he didn't get out of the vehicle. The officer then pulled him out of the vehicle. Jesse Buckley continued to sit and cry. The officer then tased Jesse Buckley, and then tased Jesse Buckley again, and then tased Jesse Buckley a third time. When this case got to the 11th Circuit Court of Appeals, the officer was granted qualified immunity. One of the judges said, well, perhaps the second or maybe the third tase was unconstitutional, but it didn't violate clearly established law that a reasonable person would have known at the time of the violation. That is, there weren't prior cases that would have put the officer on clear notice that using the taser that third or perhaps second time violated the Constitution. Therefore, even though it violated the Constitution, there could be no accountability. That is, he could not be sued in his individual capacity for money damages. There's so many cases like that that are in the federal reporters. And we might ask why. And so I'll tell you a little bit about where this doctrine came from. In the early 1980s, in a case called Harlow versus Fitzgerald, the Supreme Court unanimously adopted our contemporary conception of qualified immunity. In that particular case, which involved federal officials actually, the court said that they want to make sure that we are deterring unconstitutional conduct, but that we're not deterring officers from actually doing their job and engaging in conduct that might be wholly constitutional. And so the court said that what it was doing is balancing competing principles, and it arrived at qualified immunity. That is, has the official violated a clearly established right that a reasonable person would have known at the time of the violation? Over time, a number of courts have demanded more and more in terms of factual specificity, where they want to look to see, is there a prior case with very similar facts? The phrase that we sometimes see is materially similar facts that would have placed the officer on notice that what they did violated the law. And it seems that in excessive force cases, and more broadly in Fourth Amendment cases, that this materially similar standard, this demand for a prior case that looks a whole lot like the current case, seems to be required even more than in other contexts, say the First Amendment or the Eighth Amendment or the 14th Amendment. It seems like in the Fourth Amendment context, we see this demand all the more. And there's probably lots of reasons for that. But one reason for that is that the Fourth Amendment demands reasonableness. Right? So the Fourth Amendment says that an officer cannot engage in unreasonable searches or seizures. Technically, qualified immunity demands reasonableness. And so you can imagine a world where every time an officer engaged in a Fourth Amendment violation, that there wasn't qualified immunity because the officer inherently acted unreasonably. And as is sometimes said, that cannot necessarily be the law if there is a doctrine called qualified immunity. And so you kind of have these double layers of reasonable. You can have officers who are acting unreasonably unreasonable, and you can have officers that are acting reasonably unreasonable. And in trying to figure out the difference, right? I know this sounds a little bit like gobbledygook, but in trying to figure out the difference between reasonably unreasonable and unreasonably unreasonable, courts have looked to prior cases. This doctrine doesn't seem to apply equally across the country. That is, the 11th Circuit, where we are, which includes Georgia, Florida, and Alabama, we've been called the land of unqualified immunity, given how frequently officers receive qualified immunity. The 5th Circuit, at times, has had a quite similar reputation on that score. On the other hand, the 6th Circuit and the 9th Circuit have tended to grant qualified immunity less. But that doesn't mean that they don't grant it at all. Recently, the Supreme Court rejected hearing a case out of the 9th Circuit where officers had permission to enter into someone's home. And the officers chose instead, because they were concerned that someone inside might have a BB gun, instead they put holes into the house, and then they put tear gas and flooded the home with tear gas. It turned out that nobody was even in the house, but they flooded the home with tear gas. And the person who said that the officers could come in and who gave the officers a key to come in couldn't live in her house with her children for the months thereafter. And the 9th Circuit said qualified immunity, noting that while there were earlier cases that said that someone couldn't, that an officer couldn't engage in excessive property damage while entering into a home, that in those other cases, officers had said things like that they were engaging in property damage because it was cool. And here there was no such utterance that had been made by the officers. And therefore the officers, even if this was unconstitutional, the officers were not on notice that this violated the Constitution because these prior cases couldn't have placed them on such notice. And so that's where we are. That's what we're seeing. Now, in terms of the way forward, there are kind of a couple of possibilities. One possibility is that the Supreme Court could itself revisit the doctrine of qualified immunity and perhaps not get rid of it, but reconfigure it in a way that is more sensitive to concerns about accountability. Just this past term, the court placed roughly 9 cases on hold that were all about qualified immunity, which gave a lot of people hope that perhaps qualified immunity would be revisited. The court, however, ultimately did not accept the vast bulk of those cases. Part of what's also given people hope, though, about the Supreme Court is that you've had justices from kind of across the spectrum who have raised questions and doubts about it. So perhaps the most clear critic of qualified immunity has been Justice Thomas, who has noted that it has no basis in law, that is to say, no basis in text and no basis in history. Right? It's not like we can look to cases from the 1800s that have a doctrine that looks anything like the doctrine that we have today. There's nothing in the text of 1983 that suggests this particular doctrine. There's no real story that we can tell to explain how perhaps the people who adopted 1983 in the Ku Klux Klan Act, which was adopted in the year of 1871, there's no real story that we can tell about how they might have adopted this doctrine sub silentio. And so just from a perspective of legal formalism, Justice Thomas has raised serious concerns about the doctrine. And then Justice Sotomayor has also raised concerns about the doctrine, more so from an accountability perspective, noting that it's created an environment where, as she put it, officers sometimes shoot first and ask questions later. In her dissent in Mullinex, qualified immunity case, she used that particular language to sort of call our attention to some of the consequences of this doctrine. In my own writing, I have kind of divided this into kind of the formalist types of arguments against qualified immunity and the more Ferguson-esque arguments about qualified immunity. But in there may lie something of a compromise, given that Justice Thomas and Justice Sotomayor, they disagree on much. The fact that there's potential unity here gives some people some hope. The other potential solution comes from Congress. So a number of Congress people, including Congressman Amash from Michigan, Congresswoman Presley from Massachusetts, among others, have submitted bills to get rid of qualified immunity. And these bills take a number of different forms. Some of them eradicate qualified immunity altogether. Others eradicate qualified immunity for police departments. Then there's bills that actually try to make cities liable for the acts of their agents. Any of these would be improvements, but it may well be that although the focus is on qualified immunity, that some other solution, like allowing suits against cities, may get us to a similar place, or perhaps even a better place, with respect to accountability. Other possibilities might include placing the burden on the officer to show that they had good reason to believe that what they were doing was consistent with the law. So if they can point to a prior case that suggested that they could engage in the conduct, rather than placing the burden on the plaintiff to not only demonstrate a constitutional violation, but to demonstrate that the officer should have known that it was a constitutional violation. And perhaps there's a way to flip that and flip the burden. That too would be a great improvement on the law. We can also imagine a negligence standard as opposed to deliberate indifference. People like John Jeffries have proposed that particular standard. I've proposed the possibility that perhaps people should be able to sue the city when there's no other remedy available at law because of doctrines like qualified immunity and prosecutorial immunity. Under the doctrine of prosecutorial immunity, for example, you can't, not only can you not sue a prosecutor when they violate a clearly established law, you can't sue a prosecutor at all under the federal constitution using 1983 for acts that were taken in their prosecutorial capacity. And so as we're examining the way forward, as we're reflecting on our past, reflecting on our present, and thinking about the legacy and world that we want to leave to the next generation so that they're not engaging in the same marches and experiencing the same traumas. Among the many reforms to be considered are the reforms about accountability. Qualified immunity is potentially one of them. And I hope by virtue of this talk that you have a slightly better understanding of what the doctrine entails, although I know it gets a little bit technical, and I'm looking forward to answering questions.
All right, thank you so much, Fred. Super insightful. So anyone who has any questions, instead of putting them in the chat, if you're able, please put them in the Q&A so we can see the questions. And Fred, I had a question for you myself, and this is, I guess, going to how reasonable or how important. So I understand there's an argument on the other side that qualified immunity is important so we don't deter law enforcement officers from either joining the force or from doing their job in the first place. But I'm wondering how good of an argument that even is, because I feel like all of the things I read about whenever there's a lawsuit involving police brutality or something like that, it's usually, I feel like it's the government that do end up paying out. And so I'm wondering how important qualified immunity even is in fulfilling this purpose of protecting individual officers, when at least I don't really read cases where the officers are the ones paying anyway. Does that make sense?
Absolutely, right? So in addition to the formalist arguments against qualified immunity, and in addition to the accountability types of arguments against qualified immunity, another form of arguments that have been made are rooted in this empirical reality that you just noted, which is who ultimately pays at the end of the day. So Joanna Schwartz has been by far the most convincing and just an insightful thinker and writer in this particular space. Going back to a piece that she wrote in the NYU Law Review, where she observed that in over 99% of cases, when officers are found liable, they're indemnified. And so the city ends up paying. And so if you have a doctrine that is based on the idea, well, we're going to treat officers this way because we don't want to deter them from violating the law, and we don't want them having to pay out of their pocket unfairly, and we're going to treat cities this other way, right? Then kind of what sense does that make, right? If ultimately the city is paying. And so I think that's a fair concern. One of the points that I've raised in response to that, though, is that presumably officers still care whether or not they get sued, and they still care whether or not they have a judgment against them. There might be consequences in terms of their ability to get loans when it comes to their credit, and just more broadly, they just might not want that as a part of their record. And so that is to say, I do think that some element of fairness and due process and the like has to be taken very seriously in this context. But at the same time, there's no doubt that the doctrine as it's constructed today rests on a fallacy, on a series of empirical fallacies, actually, and that's just one of them.
Okay, thank you. Okay, so I'm going to take some questions from the audience now. So first question, what is the role of qualified immunity in police training? Are they related because clearly established rights can come from training materials, or are they not so related because the rights come from case law? And basically related to this legal doctrine, is there any hope you see via better training for police officers? So I guess just kind of the relationship between qualified immunity and training.
Yeah, so the doctrine really is focused very much on case law, and it's focused much less on training. That is to say that even if you demonstrate that an officer violated their training, violated a training manual, violated orders from their higher ups, that's not really relevant to a qualified immunity analysis. One of the places where we see this actually is in the Mullenix case that I mentioned. So in Mullenix, you had a high-speed chase, and officers were trying to figure out how to stop a vehicle. And the way that they chose to stop the vehicle was to put spikes in the road to slow down the car. One of the officers decided, though, that he didn't want to wait for the car to hit the spikes. He wanted to shoot into the vehicle. And so he got onto a bridge with his gun, and his boss actually told him, "Stand down, please don't do that. Like, it's literally about to get the spikes. There's no reason to shoot." And the officer shot into the vehicle anyway, and killed the person. And the Supreme Court, I believe that might have been 8-1. I think Justice Sotomayor might have been the only person, maybe Justice, it is 7-2 or 8-1, said qualified immunity. Because the question really isn't so much about whether or not they violated their training or violated orders, et cetera. It's about whether or not there's a prior case. And so this officer had engaged in a rather inventive way of violating the Constitution by shooting from the bridge into the car while spikes were on the way. Right. And so training itself is not directly relevant. That said, we might imagine, right, that case law is going to inform deeply the training that officers receive. And in my judgment, this isn't really a question just about more training or even about more diversity, although those are important. I would step back even further, even though I know I'm supposed to be talking about qualified immunity and the accountability piece. I really can't help but think about prevention. That is, are we asking far too much of our police? Are we asking them to do too many things? Are we labeling too many things crime and putting them into too many situations in a world, in a country where there are more guns than people, such that these are going to be inevitable consequences almost no matter what we do? Certainly we want accountability at the back end, but I think we also want to think about prevention. Training is one piece of that, but I think there's a broader conversation we're going to have about what we demand of our of the people who have pledged to keep us safe.
Okay, great. Okay, next question from Gina Hargrove. What can we do to make a difference? And I'm guessing this means like us as individuals.
Yeah, I think that's going to be different for everyone, right? Because I think everyone kind of brings different skills, different resources, et cetera. I think it's important to be informed. I think no matter what anyone's role is, right? Attending talks, reading books, et cetera, I think is important. I think people in a position to do so should think about what resources they want to donate to various organizations that are doing important work on this score. I think the time will come, maybe the time is already now, but the time will come when when Congress is seriously contemplating and considering some of these qualified immunity bills. And as that happens, writing to your congresspersons. Recently, I joined a letter with 300 other professors written to House leadership, asking them to look at qualified immunity and also to look again at municipal liability. Those of us who signed this letter thought that is an important piece of this that we don't want to be lost. And so writing your Congress folks, and then just doing your part in whatever way you can to raise consciousness about this and to kind of keep it at the front burner of our political dialogue.
Okay, great. So this is a little bit more of a specific question. Have you, or do you, Fred, include a lecture on qualified immunity for police officers specifically in your common law class? I imagine you touch on it some, but do you talk about this specifically?
I don't. I do in Fed courts,
Okay.
and then the class constitutional litigation goes a great deal into qualified immunity, which is taught at Emory by Jerry Weber. I did happen to co-write the book. I don't, but Jerry Weber teaches the class, and he's fantastic. Rarely do every now and then I include qualified immunity in a common law class. Just really kind of, sometimes the moment just calls for it, not just now, but in other moments before, where I can sense that students are hungry for more knowledge about what constitutes excessive force and what accountability looks like. And so although it's really outside of the scope of a traditional common law class, I will from time to time make kind of put it in the room somehow. But it's not a part of the traditional common law curriculum.
Okay. So back to kind of policy questions. Why not address police brutality by prohibiting the use of deadly or potentially deadly force to address nonviolent crime? So I guess when we're thinking about qualified immunity versus other ways that we can, try to get at some of the same problems, how do you see those different efforts?
Yeah, well, it's already the law that officers can't use lethal force when someone doesn't constitute an imminent threat, right? So in Tennessee versus Garner, the Supreme Court said that an officer couldn't shoot a fleeing felon in the back. In Graham versus Connor in the late 1980s, the Supreme Court reiterated that the Fourth Amendment, when it bans unreasonable seizures, that includes unreasonable arrests that involve an unreasonable amount of violence. Every arrest involves some degree of violence. That's what an arrest is, right? It's taking away someone's liberty. But when someone engages in an unreasonable degree of that violence, that violates the Fourth Amendment because it's then an unreasonable seizure. And so that's already the law. But then what ends up happening sometimes is kind of, again, an officer will engage in a way that feels almost kind of new, right? The fact pattern changes a bit. You know, the person wasn't running away, the person was leaning into a car, and so on and so forth. And so, and so qualified immunity can kind of kick in even if it's a violation, and even if we've known for, at this point, almost 40 years, that's a violation of the Fourth Amendment to shoot someone who doesn't constitute an imminent threat. Qualified immunity operates as this barrier to actually enforcing it.
Yeah, that strikes me as a particularly ridiculous part, that as long as they come up with a new way, I mean, not that, you know, I think a lot of it's necessarily thought out, you know, it's happening in the moment, but as long as it's a different, you know, technical way of doing this, that qualified immunity would cover it. It seems particularly ridiculous, but.
Yeah, and it's, you know, I mean, there are limits, and certainly outside of the Fourth Amendment. So in the Eighth Amendment context, you see the court sometimes put its foot down a little harder when you see this kind of inventive way. So there's a case called Hope versus Peltzer, where some prison guards in Alabama were, as punishment to prisoners, they were, in the middle of the summer, they were putting them on these things that they called hitching posts. So they had built these outside hitching posts that were putting people to them. They weren't giving them water. They would leave them there for hours and hours and hours. They would sometimes bring the dogs out, and they would feed the dogs water in front of the prisoners just to sort of torture them more. And the 11th Circuit said that the prison guards were entitled to qualified immunity. But the United States Supreme Court actually in that case said, you know what, this is different. Like, that was obvious. So there is this other strand of law that the Supreme Court hasn't really used it since. But the Supreme Court, at least in that case, said, well, we actually think this is obvious. And lower courts sometimes rely on that, but rarely, especially here. You don't see Hope versus Peltzer cited very much by the 11th Circuit.
Yeah. Okay, moving on. So the original justification for qualified immunity, which you discussed a bit earlier, but do you feel like that has changed in terms of, you know, was qualified immunity ever justified? If it was, have the reasons behind that changed in a way that we can think about serious reform or eliminating it in some way?
Yeah, I mean, I think it is still the case that we do need to be thoughtful about simultaneously deterring constitutional conduct and not deterring unconstitutional conduct. I think those two principles are still true. I think what has changed is that we now have 40 years of jurisprudence where, you know, the court did its best, unanimous court did its best to come up with a standard, and now there's more. We just know more. We know more about the empirics. We know about more what's actually happening on the ground. We know more about what the consequences of this are in the context of the Fourth Amendment and excessive force in particular. And we actually are in a place legally where we care more about text than we used to, right? So 40 years ago, it might not have been unusual to use the common law process to invent a doctrine to protect officers. But now we have a doctrine that is much more focused on text and the words that were said, what an ordinary person would have understood those words to mean at the time of the adoption. And so all of this together means that it's calling out for some sort of a recalibration, whether it comes from Congress or from the court. And I'm actually not on record of saying that I want to totally get rid of qualified immunity, actually. But I do think that it is in need of substantial reform.
Yeah, I like that recalibration. I think that makes sense. Rebalancing the interest, right? Okay, if the case law is stacked up so much in favor of police officers, how do we hold them accountable when it's obvious that their actions were unreasonably unreasonable?
Well, so if it's obvious that it was unreasonably unreasonable, if it's obvious it's unreasonable, then you can sue them.
Okay. Well, maybe how about if it's obvious to the rest of us, but it doesn't happen to have happened before? So, you know, they can slip in under this ridiculous, you know.
Sure. Yeah. No, they're going to be, I mean, I could right now, I could give you, I've already given you a couple, but I could give you cases. I could give you case after case where you would say, wait, what? You know, wait, that case said 3 days and this person did it 2 days. I mean, it's, and so I think we do need, I think, again, one way of handling this would be to keep qualified immunity, but to put the burden again on the officer to say, hey, like, there was this prior case that said I could do this, or there's this prior case that made me really very reasonably believe that I could do this. That in and of itself, in my opinion, would be a dramatic help. It would take seriously the concern about holding someone liable for something where they didn't have notice and kind of retroactively applying law to them, while also, not having kind of this, this list parade of cases that one scholar in one of these Q&As that I did recently, she said, it feels like a meme. Say like, but what in this case this? Oh, but in this case that. But in this, there has to be a better way.
Yeah. Okay. What impact do you think the current environment will have on police recruiting going forward and the political leanings of future police officers, particularly with so many outraged by police conduct and presumably quite unlikely to consider a career in law enforcement? Will the unintended consequence be that we end up with even fewer police who are sensitive to our concerns? That's a great question.
Yeah, it is. And I think it's certainly something to kind of be thoughtful about. And I think that the way that I have talked about this even today is with a great deal of empathy, right? Again, the way that I like to think about this and frame it and talk about it is us demanding too much of police, as opposed to kind of thinking about this as the individual officer doing, or all individual officers doing bad things, but thinking about this more systemically, because I think that's got to be part of the consideration. I would also note, though, a bit of caution about equating the number of, and this question didn't do this. It said that we want good police, but I would caution against equating the number of police with safety. I was on a call Monday on Political Rewind, where the mayor of Sandy Springs was part of the panel. He noted that in their town of 110,000 people, they have 150 police officers. Atlanta is about 5 times the size, but it's not just 5 times the police force. There's 2,000 police officers. Sandy Springs is one of the safest communities in the entire country, right? So, so then thinking about where we're putting resources in order to achieve safety, in terms of prevention, in terms of investment in education and investment in rec centers and investment in mental health, et cetera, that can work. And I think it's too easy, actually, to reach for the solution of more police. I mean, it plays very well politically, and I understand it. I'm sympathetic to where it comes from when someone's running for office. They want to show that they care about public safety. Voters often respond to this. I don't know if they will continue to. We are in an interesting moment where we might be seeing movement on that. But voters have historically responded very well to those sorts of arguments. But we have to be really, in and of itself, it's a deeply intellectually impoverished argument to just equate safety with the number of police.
Okay. Here's another great question. Unfortunately, conversations around police reform, generally, there's a lot of partisan divide there. That being said, why do you think that more conservative voices like Justice Thomas and Representative Amash are supportive of reform of qualified immunity?
Yeah, so I think it comes in part, again, from this textualist perspective, right? It's not in the text. And that certainly explains Justice Thomas's position. For Congressman Amash, it might also, I don't know, it might also come from a libertarian perspective.
Yeah.
So the Cato Institute has been a harsh critic, both of qualified immunity, and they've been a critic of the doctrine that makes it hard to sue cities, because they're skeptical of aggressive, unchecked government power, whether it be federal unchecked power or state and local unchecked power. And so that both that kind of that libertarian strand of reasoning and thought, as well as this kind of formalist, textualist strand of thought, and they're different, right? We label both conservative. They strike me as coming from different places, even in that conservative label. But I think both help explain why you see folks on the right. And then I just think that left or right, I mean, I couldn't stomach to watch the George Floyd video. I haven't watched it, but I heard it described well enough to know what it shows. And regardless of whether you're liberal or conservative, to see someone with the word that I've heard a lot is impunity, like just an absence of any care, a complete disregard for the life that was being taken. It wasn't a split-second decision like we see sometimes. And so even under kind of the most sympathetic views of law enforcement, I think that really shook a lot of people to their core. And that's not a political thing, that's a human thing.
Yeah, good point. Okay, back to a clarifying question. What is an example of a reasonable, unreasonable situation versus an unreasonable, reasonable that was mentioned before?
Yeah.
Someone was listening very carefully.
Yeah, absolutely. So the Buckley case I described, or a lot and the shooting into the house case that I described, those are examples of reasonably unreasonable, because again, the officer could have reasonably understood this to be the state of the law. So they did something that was unreasonable, right? They used unreasonable force, but they could have reasonably believed that was the state of the law because there wasn't a prior case to put them on notice, right? So one is kind of a question of what could be a reasonable conception of the law and the case law, and then the other is what is a reasonable thing to do in that particular moment factually. And so if the person was behaving unreasonably factually, they used excessive force or they engaged in a search that they shouldn't have. However, the state of the law, a reasonable person might have thought that was okay because the law had not established this particular thing as a violation in this particular setting. That's what a reasonable, unreasonable violation is. An unreasonably unreasonable violation. And by the way, I know that's a really complicated way of describing it, but it's Justice Stevens used to talk about it this way, and it used to drive him crazy, and he would take opportunity to kind of point out that that's what the court was doing. But an unreasonably unreasonable, it could happen because again, there is a case that put someone on notice in the past. So there is a factually similar case. Occasionally, this is very rare, it can happen by virtue of the text. Like this is really rare, but so the Fourth Amendment says what should be in a warrant. And so if you don't put those things in the warrant, that violates the Constitution. It doesn't matter if there's a prior case, right. That there's no qualified immunity because the text is clear, but that is, there's not very much in the Constitution that arises to that kind of level of textual specificity.
Okay, somewhat related, I think, to the first point. Why do you think courts seem to be so hesitant to use cases to at least be clear what violations are clearly established?
Yeah, so good question, right? So, and what the questioner is in some ways alluding to, I think, is you can wind up with the following scenario. A person engages in let's call it conduct A. So kind of imagine that somebody doing something unconstitutional. We'll label it conduct A. Person engages in conduct A, and it perhaps is unconstitutional. And a federal court says, well, we're not going to tell you whether this is constitutional or unconstitutional, but it's not a violation of clearly established law because no one has said anything about A before. And then another officer engages in conduct A. And then again, another court says, well, there's no case saying conduct A is unconstitutional. So we're not going to tell you whether it's constitutional, because we don't really need to. There's no need for all that dicta and such. So we're just going to say that there's no violation of clearly established law. Anyway, and you can imagine that going on and on and on, right? And you can imagine this happening in the excessive force context more than others because other areas of law get developed. So the particularity clause or an unreasonable search of someone's home that's not rooted in a claim of violence. The law is a Miranda violation and so on under the Fifth Amendment. Those often get worked out in the criminal legal system by virtue of suppression motions and the like. That's not so much true for excessive force, right? It's these Section 1983 suits or nothing. And so that's an area of particular frustration. There was a period of about 10 years in which it was the law that courts had to answer the question of whether it was constitutional. They couldn't just skip to the question of whether it was a violation of clearly established law. So beginning with a case called Wilson versus Lane in 1999, and it was reaffirmed in a case called Saussure versus Katz in 2001, the court said that it was important to answer the first question. That actually turned out to frustrate a lot of people on the left and the right. So just to be really blunt about it, there were things that people on the left, there were cases where they saw people saying things weren't violations, and were like, wait, that might be a violation. I don't like that that court is saying that's not a violation. They didn't have to say that. And then you had folks on the right who had the same view, right? Who were like, actually, wait, why are they saying that is a violation? And they didn't have to say that was a violation.
Yeah.
And that, I think, sometimes might have been even more frustrating because there was also a period in which you couldn't seek cert at the Supreme Court from those sorts of cases because the defendant won. So what was there to seek cert from? I mean, that actually has been amended subsequently, but that was once the case. And so you had this frustration on the, across the board. And that's when big changes in law often happen, when you have everyone in agreement. And there everyone was in agreement. You had there was a judge, and Judge Pierre Laval, who wrote a piece in the NYU Law Review called Dicta About Dicta, which expressed his frustration with having to decide the first question. And so now district courts have a tremendous amount of discretion with respect to whether they answer the question of whether there's a constitutional violation. And you might imagine that in instances in which someone has a particularly heavy docket, answering a question they don't need to answer just with that discretion is just not going to always be a priority.
Yeah, but as a result, they're not really establishing.
The law doesn't get established in the first.
Yeah.
That's right.
Okay. Are there other professions with this legal framework regarding the actions taken and not taken, or is it only law enforcement officers?
Great question. Now, this applies across the board. So this applies to any government official who's being sued in their individual capacity for money damages, for violating federal rights. So this applies to federal officials who are violating someone's federal rights, or who have violated someone's federal rights, and you're trying to sue them in their individual capacity for money damages. And it involves state officers who have done that. But I keep saying officers even now, and I mean officials in this context. So it could be a teacher, it could be a principal, right? I recently, in one of the neighboring counties, Paulding County, right? There was the student who was temporarily dismissed for taking a picture of a crowded hallway. Yeah. When I was asked about it by the Washington Post, I said, well, that could be a violation if they aren't getting rid of everyone who's posting to social media. Right? If they're picking on her because of what she posted, that's a First Amendment problem. Anyway, after national press, they reversed. But in any event, I raised this to say that would be a 1983 suit, and qualified immunity would kick in if someone wasn't on notice that what they did violated the law. The reason, though, why we talk so much about qualified immunity in the context of excessive force is because in the First Amendment context, it's more likely to be obvious. So if you have a prior case that says you can't sanction someone on the basis of their content of their speech and their viewpoint, that is often enough. Not always, but often that's going to be enough. But if you say to officers, don't act unreasonably, that might not be enough. And that's the complication. And that's why I think you see it so much in the excessive force context.
Okay. Just a related question on that. I mean, are any of these proposals by Booker or Presley or any of the others, are they kind of blanket, or are they as applied to, it seems like it's a bit different when we're talking about police officers. It's
a mix. So there's a number of bills. Some of them, or at least one of them, I won't say some of them, at least one of them is specifically about police. Congressman Amash and Presley's bill gets rid of it more broadly. And then some get at the municipal liability question, and some don't. This isn't, to me personally, this doesn't feel imminent. I mean, this feels like more of like a January 2021 issue than a. But at some point we're gonna have to figure out which one, right? But some of the different bills do different things.
Okay. I'm skipping some of our faculty colleagues' questions right now, Fred, trying to get to the other ones because I assume they know how to find you. So I apologize to those on our faculty that I'm not answering currently, although we may have time. Next question. The sheriff in my county is currently pushing the ideology that if the police are defunded, that they will not have the good officers applying, with good in quotes, and they will have to lessen their minimum qualifications due to the decrease in pay. How would you respond to this point? If local and state governments are to redirect funding from police to other departments, what types of changes do you think we'll see?
Yeah, I mean, I don't know, right? So I mean, let me back up a bit. So first, I want to say, right, like I can talk about qualified immunity all day, and I do have thoughts more broadly about policing, but there are folks who focus specifically on questions of policing, including questions of defund and abolition, who dedicate their life's work to that. And I think by writing about qualified immunity and sovereign immunity, I've kind of found myself more and more in a space of talking about policing. But I do want to kind of put that qualification on it that I haven't written a policing article in my life. That said, recently in Atlanta, the defund, what was called the defund bill, what was really interesting about it is that in the same budget that attempted to temporarily reduce the budget, it had a raise for police officers. So officer pay actually went up in that proposed budget, even though there was other aspects of the budget that were going to be set aside while the city discussed how to reallocate that toward other aspects of public safety. So I'm not sure that that reallocating funds necessarily means lowering police pay, because in the Atlanta context, I guess that's the best example, because it literally at the same time, the very same people who voted to set aside the money, and there were 6 city council people who voted to do that, they all were on record saying that they wanted better pay. So I don't think that's any question.
No, that's actually a great, that's a great point. It's not less for the individual officers, it's just a restructuring of what it is the police are doing, right?
Right.
Kind of a related question. How do you see the reform of qualified immunity syncing with broader reform goals, like these kind of like defund the police or restructuring or those sorts of goals? Do you see that there's kind of overlap there?
Yeah, I do. I mean, I think it's important. I mean, obviously I think it's important. I'm a Fed courts professor, right? So I think it's important to have accountability. And I think that's true for lots of reasons. I think it's true because we want to make the individual person whole. I think it's true because we want courts saying that things violate the law when they in fact do violate the law. I think it's true because of the deterrence function that it provides. I think it's true because of what Monica Bell calls legal estrangement, the sense that when people feel that there is no accountability and that when the government can act with impunity, it makes them feel deeply estranged from their government in a way that should be concerning for any democracy. I think it's true because of the Tom Tyler types of arguments about procedural justice, that people are more likely to comply with law that they agree with. So I believe all of those things, and qualified immunity and municipal liability are both important pieces of that particular story. I also think, even though I'm kind of talking out of both sides of my mouth because now I'm about to talk about the thing I know less about, I also think, though, that at the prevention side of things, asking the question of what is it that we really want to continue to label crime? What are the situations we want to continue to place officers into, and what are the ones where we don't want to do that anymore? And what are the instances in which we want to kind of bolster other types of resources like mental health, et cetera? That those are just not so much as a professor even, but as a human being and as a Black man in America, I want accountability. I mean, if not to make it too personal, but yeah, if I get shot and I survive, I want to be able to sue. And if I get shot and I don't survive, I want my family to be able to sue. But I'd rather not get shot. And so the prevention piece of this is also, I think, super important, even though my scholarship and my training and knowledge is more about the accountability piece.
Yeah, that's okay. Yes. So I have a question that's going to push you on that other part that you're a little less, have a little less, I guess you don't write about as professionally. So one of our attendees agrees that police are overtaxed. Too much is expected of them. They assume the role of social workers, psychologists, in addition to have to being peacemakers and enforcer of law and order. What specific changes do you suggest to alleviate these additional responsibilities that they really shouldn't be bearing?
Yeah. So one piece is to kind of think about people who aren't police officers, and who actually are perhaps social workers, responding to certain types of incidents. And so you're beginning to see that in some cities um, where for certain types of calls, right, that part of what the person who's getting the 911 call or what have you, the part of what they need to assess, are there arms on the scene? Is this a violent and volatile situation, or is this not a violent and volatile situation? Because it might not be a situation in which an armed agent of the state, right, where we use kind of the most violent tool that local government has, we might not have to respond with the most violent tool. We might be able to respond some other way. And so I think those reforms are important, and I think we'll soon have kind of a laboratory of democracy on this front, because
Yeah.
more and more local governments are experimenting with that. I don't predict that Atlanta will be at the vanguard of that. I think by the time we act, there'll be a lot of data to use. And then beyond that, I think we really should, this is really outside of my wheelhouse, but I believe in decriminalizing things like marijuana. When I read the new Jim Crow, I was actually shocked at how much of the carceral state is built on the criminalization of this thing that's becoming legal more and more.
Yeah.
And often the people, though, who were convicted of it, now they can't actually participate even in the places where it's becoming legal. They're banned from it because they have criminal records and so forth. And so thinking about what we even want to continue to label crime, I think that also would be potentially helpful.
Yeah, I agree. Okay, back to qualified immunity. Is there any thought around the idea that the doctrine of qualified immunity actually incentivizes officers to use excessive force against communities of color, especially given that racial profiling is still a component of police training?
I don't know if I would say that it incentivizes. I want to think more about that word. But certainly if someone is in a setting where they believe that the likelihood of accountability is relatively low, then one of the things that we do like to think in the law, right, is that that part of the role is a deterrence type of function. And so, if someone at the specific officer level believes that there are not going to be consequences, then on balance, one is going to imagine that's going to result in more instances of misconduct. Now, all of that said, you can also imagine that you don't even make it easier to sue the officer. You could make it easier to sue the city, and you're putting the emphasis on, in torts terms, the cheapest cost avoider, who's in the kind of the best position to think about some of the more systemic things that I'm talking about, right? Like the officer, it's harder for the officer to think about, do I decriminalize marijuana? Because the officer can't do that, right? It's harder for the officer to think about, is this a call where I should respond with a gun or not? Because the officer isn't going to be equipped with that. The officer is going to have a gun. That's what officers do. That's what that part of the government, that's what they do. And so kind of putting the burden then on the policymakers who are actually in the best position to, in a systemic way, fix this, might in some ways make even more sense. It's hard because we're really focused on qualified immunity, and yes, that's better. I mean, yes, reforming qualified immunity is better than not reforming qualified immunity, but I find myself not able to help myself from mentioning municipal liability as well.
Okay, well, on that point, we have a question. How do you justify civil suits against cities when the settlement or cost of insurance is ultimately on the backs of taxpayers?
Yeah, right. No, great question. So, well, first I'll just note that just broadly, right, is that when an employer acts through the acts of their employees, And so that's true of the government just as it's true of a corporation. Now, that said, to your point, right, in the context of the government, it's the taxpayer who's ultimately paying. In the context of the corporation, it's not the taxpayer who's ultimately paying. So is it, in a sense, unfair to the taxpayer? I guess if we conceptualize the taxpayer, though, also as a member of the body politique, right? That if we think of the government as being of the people, for the people, by the people, rather than thinking about it as just kind of this entity somewhere that we're paying our taxes to, then we're all mutually responsible when the state violates the Constitution, even when it's an individual officer that it's on us, right? And you see people kind of stepping up across the country, right, and taking this kind of responsibility and this ownership and saying enough is enough. Part of, I think, where that comes from is the sense that, not in my name, right? As a member of this community, as a member of this country, as a citizen of this country, not in my name. Stop doing this. And so that's sort of, they get, from a democratic perspective, we may want the taxpayer to think about this, because the taxpayer is also the voter. Now, if you read my writing, I have this piece called "Local Sovereign Immunity" in the Columbia Law Review in 2016. I express a lot of sympathy with that particular concern, and that's why I end up with some reforms that make municipal liability easier while also taking into account the concern that you just raised. But all in all, I think that's one way to go. And then lastly, I'll just say, right now, even if the government official, if a high-level government official acts negligently, right? So put aside respondeat superior liability for a moment. You can't even hold a city liable for its own negligence, right? And so, it's not respondeat superior liability or where we are now. There's room in between that too. That listeners who are concerned about taxpayers paying the bill might be also sympathetic to potentially.
Okay, so back to what might be done to reform qualified immunity. Justice Kavanaugh and Thomas have been writing about the role of precedent and stare decisis and when the court should overrule its own precedent. Do you see qualified immunity case law getting drawn into a broader discussion of this role of precedent?
It can be, sure. I don't, it's into the broader conversation about precedent and into the broader conversation about text, right? So text can't support it. History can't support it, at least history as conceived of it when 1983 was adopted. So then, precedent is kind of the strongest tool or leg under the table for qualified immunity to stand on. And so, sure, you might see some of that. Right, in this particular court, though, the version of the court that we have at this particular moment is not the most married to the notion of stare decisis. So there's been sovereign immunity cases, for example, kind of going in the other direction, where the court has said, yeah, we know that it's been the case since, I'm thinking about a case that overruled a sovereign immunity case from the 1970s that was just kind of well established. Everybody understood it to be the law until a few terms ago, and they overturned it. So sometimes formalism in the way of text and the words as they would have been understood at the moment of the Constitution or the statute's adoption, there are members of this court for which that is more important than precedent. And if that were to be applied in this particular context, that could be a basis, nonetheless, for getting rid of qualified immunity, despite Harlow versus Fitzgerald. I mean, I also would just again note, Harlow versus Fitzgerald, not only is it based on, not only does it articulate a version of statutory interpretation that has subsequently been disavowed, it also rests on things that we know now to be empirically false, right? And in the past, stare decisis has been less apt or less relevant when it's shown that it rests on a faulty empirical foundation.
Yeah. So would you say is change more likely coming out of the courts or out of Congress?
I don't know. It might be one of these moments where the courts are watching Congress first, that they prefer Congress engage in the solution. And so they might be watching them, because it's sort of interesting to see how they had all these cases. They were building them up. They were holding qualified immunity case after qualified immunity case. And then this movement happens. And then they actually are like, oh, actually, never mind. We're not going to take these cases. And so it's like, it's all that to me. I don't know what happened, but it almost suggests that the fact that that this was on the radar of the politically and democratically accountable bodies, that the court wants to give them the first crack at it.
Yeah, hence your statement about January 2021.
Sure.
And okay, so I think I'm going to do one more quick question. I think we have time. Does the 14th Amendment balance qualified immunity if enforced?
Does the 14th Amendment balance qualified immunity?
Yeah, that's the question.
Well, just kind of in terms of the architecture, right? So the 14th Amendment guarantees equal protection and due process, among other things. Section 5 of the 14th Amendment gives Congress the ability to enforce the 14th Amendment. The statute we're talking about mostly here, Section 1983, was passed with Congress using its power to enforce the 14th Amendment. It didn't say anything about qualified immunity, but the courts created the doctrine of qualified immunity in the early 1980s. But the statute itself doesn't say anything about qualified immunity, right? So that also might help explain why courts are not really, they know they made the mess. And so if there's someone else who is interested in fixing it, they might prefer that because they might not be confident that they might not make a bigger mess.
Right. Okay, Fred, thank you so much for educating all of us a bit about qualified immunity and the important role it's playing, especially in what's going on in the world around us right now. Thanks you to all attendees for joining. I'll just note that we have 2 more lecture series on the calendar. There'll be more in the spring, but we currently have scheduled for October 1st, Kimberly Jacob Areola, who is from the Charles, she's in the public, she's the Charles Howard Candler Professor of Behavioral, Social, and Health Education Sciences. She's going to be talking about healthcare and racial disparities we see in healthcare. And then on November 5th, we're going to have Carol Anderson, who is the Charles Howard Candler Professor of African American Studies. She's going to be talking about voting and the electoral process. And so I hope that all of you can join. You'll receive more information via email and announcements about those future talks. So Fred, thank you so much for joining us and making this a great first series.
Okay, thank you.